All right. So first things first, I'd like to welcome everybody to our special session for the Beginning Farmers and Ranchers program. Tonight, we have a special guest from the Nevada Division of Water Resources, Malcolm Wilson. He's a water rights sections chief, and he is going to share with us some basics about water rights in Nevada. And during the time, he's going to pause between each section to provide opportunity for questions. You can put your questions in the chat or live. You can ask them in person, and then he'll add another opportunity at the end if there needs to be anything else clarified or if something hasn't been covered. But just a little introduction about Malcolm Wilson. He's a Nevada native who earned his Bachelor's of Science and Master's degree in Chemical Engineering from the McKay School of Mines at the University of Nevada, and is licensed as a professional engineer in civil engineering by the Nevada Board of Professional Engineers and Land Surveyors. He has worked with the Nevada Division of Water Resources for over 18 years, performing a broad number of roles, and he currently manages the division's water rights section. So welcome, Malcolm, and thank you so much for coming and sharing your expertise. And I will hand the mic over to you.
All right, thank you so much for that introduction. I'm glad to be here. We like to have opportunities to do some outreach and provide some education. So as Jessica said, I am a water rights section chief here at the Division of Water Resources. And the presentation I'm going to provide here basically give pretty very high level overview, kind of big caveats that there's some generalities and there's always some kind of nuance that might not always come through in such a 30,000 foot view of the what water rights are and application process and the other items that I've shown on the outline here. These are basically the sections that Jessica mentioned, where as we get to the end of it, I'll offer some opportunity for questions. So I was going to start out with kind of the basics of water law and water rights in Nevada. Here's all the NRS chapters. There's some other ones that get pulled in a little bit, but these are the main ones that we operate under. And the focus for the ones today are going to be chapters 533 and 534. That's the ones that are governing most of what you would be dealing with if you were to engage with acquiring a water right or seeking an appropriation for one. So there's two foundational concepts that support Nevada water law. The first is beneficial use, and the other is prior appropriation. So let's first say, well, what is a water right? There's a couple of sections in the statutes that kind of put the sideboards up on what use of water is. So the first one, it states, I'm going to go ahead and read it even though it's on the screen. The water of all sources of all water supply within the boundaries of the state, whether above or beneath the surface of the ground, belongs to the public. So the water itself belongs to the public. And then the other section I have up here is subject to existing rights. All water may be appropriated for beneficial use as provided in this chapter, not otherwise. So what those come down to is a water right is the right to the use of the water. And so you wouldn't actually possess the water, but you possess that right to use it. So kind of give a demonstration of what a water right is in terms of its practical nature. I'll walk through a few features. It's going to have some kind of source. You know, is it going to be underground water of a particular basin. So you have a well that taps into an aquifer, say in the Eagle Valley basin.
I can see the slides now.
If or if there's a spring source or a stream, like the Truckee River, it's considered a stream source. The manner of use, the examples I threw up here: irrigation, stock water. I figured that would be the most obvious examples for this group, but it could be also municipal, quasi-municipal, excuse me, wildlife purposes, and others. Point of diversion, that's going to be, we need to figure out where the location, where that water is going to be diverted from, whether that's the well location if it's groundwater, or whether that's where the diversion works have been installed like in a stream, or say the spring location, if you have a spring box that's collecting the water and improving an improvement on the spring. And I'd say tied to a found corner, that's a survey reference. So it needs to, from that point, be shown by a bearing and distance to a found corner within the public land survey system. Similarly, place of use. Where is the water going to be placed to use? And those are described within that public land survey system. So if you've seen on deeds or anything, or you have a description that says southwest and northeast of section 5, township 23 north, range 53 east, MDB&M, something like that, that is that PLSS description. Diversion rate. So how quickly can you divert the water? So I describe it here as the instantaneous flow rate, and those units in parentheses is CFS, that's cubic feet per second. Now, I guess the way to think about this would be if you were turning the valve on your faucet on your sink, are you allowed to turn it just a little bit and have it just trickle out, or can you really open it up and have it pour out? That's kind of what that diversion rate is describing and limiting. Duty. So that's the volume allowed for over the course of a year, or if it's not a full year that you're allowed to use the water over the season. And we describe the units in there as acre feet, and AFA means acre feet annually, or AFS is acre feet per season. And so an acre foot, if you imagine like a football field sized area, a foot deep in water. That's about the quantity. And that's about enough for maybe 2 kind of urban households to have over the course of a year. That'd be their usage. And then, as I kind of alluded to just a second ago with a season, is period of use. So there's a time frame in which the water right can be used. A lot of times it's just annual, so the period of use would just be January 1st to December 31st. But at times it's also could be a shorter season. Say you're limited to an irrigation season like March 1 to October 31. So having addressed kind of what makes up a water right, let's get into the first of these, how do you call it, pillars or foundational structures here. So again, I'm going to come back to the statutes a little bit. I'm not going to read them verbatim. But the water right is defined by its beneficial use. There has to be some use for that water for you to retain that right. And these show up in different ways throughout the statute. It comes up in terms of trying to establish your right. You might get an application approved, so then you have a permit, but then you have to perfect that right by actually using the water. And then however much you actually use, and how much you actually use will be that limit of the right when we issue a certificate on it. And don't worry too much about the exact terminology here. It's just kind of the overall concepts I'm trying to get. And then and then the second part here, it's expressing is that you have to also maintain the use. If you stop using the water, if you no longer need it, the right to it ceases. So to kind of summarize those ideas, you can say you must use the water beneficially to perfect the right. And then even once you've perfected it, you could still lose the use of that water if there's no longer a use for it, or you've failed to use it. And there's specific statutes at different stages. I probably won't get into too much, but I will touch on it when we get to a later section on the application process. So next, I have the other pillar, the prior appropriation doctrine. So prior appropriation. This is summed up colloquially as first in time, first in right. So whoever appropriates the water first has the right before anyone that was a subsequent appropriator. So the idea would be if someone was appropriating the water back in 1953 of a particular source, they would have the senior right, and each new appropriator in turn, in this little timeline example here, would be more and more junior to that senior right. So I'm going to make a little example here to try to explain what I mean by this, by senior and junior rights. Let's say we have a little creek. Someone has got an appropriation on it. You have a point of diversion that pulls off on there, a little canal or ditch, and then it flood irrigates a field. And when they established that right, they had a priority date of March 15th, 1945, and the water amount that they used, and I'm just giving the diversion right here to not get bogged down in too many details, of 2 CFS, so 2 cubic feet per second. That's the limit on their right that they can pull from the stream. And then let's say later on in time, even though they're further upstream here, another person is able to establish a water right at another point of diversion. They have their ditch coming off, they're irrigating a field, and they establish it at 3 cubic feet per second. So they're going to be, since they're later in time, the junior right, and the earlier in time right here, the green one, is the senior right. So let's say in a given year that on April 1st, we have a flow of 6 CFS on the stream. It's enough to satisfy both rights. They can both divert the water. We get later in the year, later into summer, the spring runoff is kind of run its course. How the flow is more like 3 CFS. Even though this person in the blue here is further upstream, they'll get cut off, or as we would say, put on regulation, because they're the junior right. And unless you allow that 3 CFS to flow down, that senior right wouldn't get satisfied. And I use a surface water example here because that's easier to conceptualize, but all the water rights have a priority date, including groundwater rights. All right, so kind of with that a little quickly, I'm afraid, but I'll have a chance here now. If there's any questions on beneficial use or prior appropriation or the basic elements of a water right, feel free to ask them now.
So in the first slide, one of the first slides, you said if we don't use water, it ceases. Is that right?
Correct. I mean, there's more to it than that.
Mm.
So I can go into a little more depth with it. So and again, I'll get into this a little bit as well later on, but you have an application, it gets approved, you get, and a permit is issued, then you have to prove up on that water right by actually placing it to use. If you fail to ever do that, if you don't put it to use, or you fail to, you know, establish that right, or either whether it's the full amount of the permit or a portion, then it could get canceled and then that right goes away. Or say, even if you do that and you sufficiently prove that beneficial use here, I have this 100 acre-foot water right. I put all 25 acres at 4 feet per acre to use. I proved up on it. Field investigation looked good. Certificate issued. If that water ceases, what then can happen is forfeiture, and there is a noticing that would occur. So after 4 years or more of non-use, we would send a notice of that non-use and provide an opportunity to either cure the forfeiture by putting the water back to use, or making application to for extension of time to prevent the working of a forfeiture. If neither of those things happen and it goes beyond 5 years, that 5 years of non-use can lead to the forfeiture of the right. So those are the ways that you either lose it kind of in the process of trying to prove up, or you can lose it later after the certificate is issued by failure to continue using it.
Rich, would you like to ask your question next?
Yeah, great, thank you. Just curious, in the example you gave of the creek and the flow rates, would the senior had the 2 CFS flow? In theory, if the stream was flowing 3, that would leave 1 CFS available. Would the junior then be able to utilize that 1 CFS or not?
Okay. It would depend on some more details in how the decree is written, how the stream is managed. There might need to be a certain amount left in the stream to provide that head, that hydrostatic head, to push the water to make it to the next user down. What will happen is if it's in that simple system, there might not be that level of management, but a more complex system that has a water master or a water commissioner. They'd probably have a schedule that, based on a rate at a certain measuring point, certain dates get cut off. It's simpler than just kind of reducing flows in a certain diversion. So it's very dependent on the exact stream and if it's in what kind of decree maybe was issued, or how the permits are been written.
Awesome, got it, thank you.
Mm-hmm.
So Malcolm, we have a few questions in the chat as well. One is, how are the senior rights enforced in July? I don't.
Oh, so again, if that was really just 2 people on the system, it's likely they just kind of have their own agreement. If it's actually a system that's under a decree or has a water commissioner, there's probably, as I was kind of describing just a second ago, there's probably some kind of schedule of delivery based on priority date and amount of flow at a certain location, some kind of gauging on the stream.
And then there's another one. It seems like rainwater falls under the statutes, under these statutes, correct? Is that true? And can someone with water rights collect snow melt from their roofs, for example?
I will touch on a little bit further on about precipitation capture. But yes, and generally speaking, if rain's coming down, the idea is that's what's helping, at least to some extent, recharge basins. And so you really should have a right that appropriates water in order to utilize it. Can't really appropriate a cloud or have a water right that's whatever falls here But I will talk about a couple of exceptions to needing a water right. And one of them is for single family residents, you can have rooftop capture for outdoor use.
Those are all the questions right now.
Okay. Well, I'll move forward and I'm fine with if something else comes up that triggers something that's back to a previous section, that's fine to bring that up to the next break. So as I was just hinting at and answering the last question, when is a water right needed? So a default is you'll need a water right to use, whether it's groundwater or surface water. But there are exemptions to that are in the statute. The biggest one and the most, or at least in the statutes, and most prominent is a domestic well. So a well that's been drilled for serving a single family residence. And I'll get a little more detail in a minute. And then again, I'll touch on again that there is this de minimis capture of precipitation that's allowed for in the statute. So either the rooftop of a single family dwelling, you can capture that water and utilize it for your landscaping or outdoor use like that. The other one is guzzlers for wildlife use. You have to either be the Department of Wildlife, or you have to have some kind of relationship with the Nevada Department of Wildlife in order to utilize that exception. And there's also limits on the size. And then the third one here is waivers. Those are meant to cover things like highway construction. So NDOT contractors NDOT would have the waiver, and then their contractors could then utilize the water temporarily from a well or a standpipe or something to during the construction of a highway. So one of the preemptive questions that I had was kind of distinction with say municipal supply. So when you're living in a city and you turn on the tap, there's water that comes out, you're buying that from your municipal water system. Well, they have a water right, or probably very many water rights. That is how they are able to divert the water for that municipal purpose that then they would supply. So I have, as an example here, I threw up a map for the Truckee Metals Water Authority's place of use as it is. I think this is the most recent one, or at least fairly recent one. As they grew, that size of the boundary here also grew. And then they have on this map as well the various points of diversion that are allowed. This is for one of their Truckee River water rights. Well, actually, quite a number. So that municipal supply that you're receiving, if they have water lines that can serve your parcel or your location where you want to use the water, can go to them, pay them their rates for it, and you'd just be operating under their water rights. Now, sometimes they would want you to, in order to serve you, come up with a water right that you would dedicate to them that they could then change and utilize so that they have sufficient water rights for you to cover your use as well as the existing uses they have. So again, I mentioned there's probably the biggest exemption to the requirement for a water right is a domestic well. In the statute, there's two main sections to look out for. One is the definition of domestic use. So it's a single family dwelling, and in certain, if it's allowed by the local ordinance, if they're allowed to have an accessory dwelling unit, again, a colloquial term for that is like mother-in-law quarters. then use water from this well for, you know, your normal indoor uses, your watering of your landscape. If you have animals, you can water your animals. And it's limited to a certain maximum as set forth in this other statute, which is here. And it's in this statute that not only gives that quantity of water, that 2 acre-feet per year. That's for domestic purposes, underground water, it's a well. So you don't, there's no freebie domestic use out of, say, a spring. You would need a water right for that. But this is also the chapter that provide, or the section that provides that elements of this chapter does not apply in the matter of obtaining permits. That's where it creates this exception. It carves out domestic wells. But go back here a second, but they have to meet this definition right here. Pictures, basically an example of a little domestic well. It goes up on Mount Rose somewhere. So there's a few other provisions. I'm just going to point them out real quick. Like any well, they have to be drilled by a licensed well driller. So they file their well drain logs with us. There's certain circumstances where you'd be required to plug a domestic well. For example, if you now could be supplied, there's a water line from a municipal supplier, you know, city or utility, and then you have work that needs to be done in your well that would require a well rig to come out. We might deny that request and say, no, it's time to plug your well and hook up to the municipal system. And there's waivers also to allow it to not have to happen like that too. But it is a possibility. And then the last subsection here is kind of what was described earlier. You're allowed to have that accessory dwelling, that mother-in-law quarters, but you still can't exceed your 2 acre-feet. So relatively short section, but any questions on that or from the previous section? Take some time.
What were the waivers you were referring to that you would be allowed to, say, be on municipal and get your well worked on?
Well, you wouldn't be both on municipal and be able to say refurbish your well. It's like an either or. So if you weren't gonna, so you wouldn't be required to hook up if the water line isn't actually adjacent to your parcel, or if sometimes there's a cost factor that you can request. You know, it's undue burden to have to, you know, pay the $20,000 hookup fee versus just the, you know, getting a well driller out to fix the well I already have. And so it is possible to get a waiver for the plugging of a domestic well. But if you were to hook up, you would have to plug the well.
I got you. Thank you.
We have a few questions in the chat. The first one is, can I allocate my neighbor's unused residential water for my own so I can use more than 2 acre-feet a year?
Excellent question. And the answer is no. They're carved out exemptions from having to have a water right. So you don't actually have a right in the sense of the something that's a property right that's transferable. It's just you're allowed to have a domestic well, and if it's in, you can utilize it. If your neighbor could put in a well, and they do, they could utilize theirs up to that 2 acre-feet for their residents, but you wouldn't be able to share that in that sense. You need a water right that would allow for that quantity of water to be utilized.
The second question is, will we discuss the distinction between certificated and non-certificated rights?
Yes, I can try and make sure I'm very explicit when we get to that.
And I have a question actually about domestic wells. Are they monitored at all? So,
Normally, the default is no. And but if there's a question about maybe they're utilizing too much, maybe a neighbor complains, they're irrigating their 3-acre lot, with lush green grass, how are they doing on a 2-acre feet? We might investigate that. It might result in an order where we say, oh yeah, you install a meter, demonstrate that you're not going beyond what you're allowed in the statute. So at times there are particular cases as it comes up where we might require that. But otherwise, for the most part, no, there is not a meter on domestic wells.
Rich, did that answer your question too? I think Rich had the exact same question. So, and that is all we have for this section, I think. Yep.
Okay. So we'll get into applications now. Probably the kind of more of the practical elements here. So there's 2 paths to acquiring a water right under our appropriation system. There's kind of a trying to think of how to put this. There's another type of right that I'm not going to get into called a vested right, that basically something that was established prior to the water law. So I'm not really going to get into that. So if you hear something about a vested right or adjudication, I'm not going to get into that too much, other than it's possible to make changes to those through this same process here. So in terms of these 2 paths, either you can make an application to create a new right, we call it for a new appropriation, or to acquire an existing right, update the ownership into your name or your entity's name, company name, however you acquired it, and then make an application to change that right to how you're going to use it. So on the left here, kind of recognize some of the same things that I mentioned when I said, here's the features of a water right. But when you're making an application for a new appropriation, excuse me, that's the kind of information we need to know. What are you asking for? What's the, what's the source? How are you going to use it? Where? How much? For how long? But beyond that, we also have, for a real critical piece of information, is the name of the appropriator. And it's important to get this right on the application because you're creating this property right. And so that's going to be who owns that right, whatever comes of it. At this point, even though it's still just an application, once you've turned it in, but it has the potential value of becoming a permit and a water right. Beyond that, it's more detailed description of what's the project going to be, what's your proposed diversion structures. So, a lot of times if it's groundwater, it'll be a drilled encased well, or they could be describing an existing well. Oh, we already have our domestic well. We just want a water right here so we can use it for commercial stock water uses. So those in the justifications, why are you asking for as much as you are? Well, that's how much 500 head of cattle need. And then there's specific details depending on that manner of use. So like an example I just gave, if it's a stock water right that you are seeking, then you would need to tell, say, the number of and type of animals. So 500 head of cattle, 2,000 sheep, however many that you're seeking. If it was an irrigation right, it's, how many acres? And of course, it would have to be within that place of use. So, 480 acres. And another thing to point out here, or discussing it, is with the manner of use, you're limited to one major manner of use. You can add to that domestic use, so you could apply for irrigation and domestic, or commercial and domestic, or you could just apply for irrigation. If it's just going to be a big irrigation well out in the field, there's probably no point in putting and domestic, because you aren't actually going to draw any domestic water out of it. So, but you could not do something like, say, irrigation and stock water, because those are two major uses. You would need two separate water rights, one for each manner of use. Now, change applications are similar. I'm going to kind of walk through a little bit more, though. So the source, under whichever right that you've acquired and you're seeking to change, has to be the same source. So if it's groundwater in the, say, Eagle Valley Basin, I keep using that example because that's where I'm sitting right now, then it would have to still be groundwater in the Eagle Valley Basin. If it's going to be water of the Truckee River, and you're going to change, say, the place of use to your parcel from the neighbor's parcel, since they aren't using it and they sold you the water, well, it's still going to be the Truckee River that you're getting that water from. Manner of use, like a lot of the features, you have to describe both what it was under the existing right and what you plan on changing it to. And if you're not actually changing the manner of use, say it's going to be irrigation and it was irrigation, you still just mark those to fill in the form, make sure it's clear what is happening with it. Point of diversion, again, existing and proposed. If it's the same, you only have to enter it once and then just say same as for the other question. Place of use, same issue. Sometimes you're only changing a portion. Let's say there's a 120 acre irrigation right that's been certificated, and you just want to move 30 acres of it. You got to tell us which 30 acres. Diversion rate, again, if you're only changing a portion of the right, what portion are you changing? Same with the duty. Period of use, and I'll get into a little bit more when I take you through what's on our website and resources that we have for people, and show some of the forms. So what I'm saying with this note here is, if you're going to change that period of use, say, well, I'm changing this irrigation right to a commercial right, so it had this period of use that was an irrigation season, March 15th to October 15th, but my commercial use is going to be year round, so I want to change that. So if that was, it's already in my example, a manner of use change, because you're going from irrigation to commercial. But if you're going to irrigation and you're only changing the period of use, then it would still be a manner of use change. It's just the way that we would reflect that that's the type of change that's occurring. So regardless of whether you're making an application for a new appropriation or a change of an existing right, there'll be an application form. There's a variety of different types of water right applications, several of which are very specific, such as a environmental right, which is if there's an order from our sister agency, NDEP, Environmental Protection, that says, oh, you got to clean up the water here, and you're going to do some bioremediation project, and you can request that right. So that's a very specific form that we have in there. Otherwise, we just have two basic forms, and one is for the new appropriation, and one is for the making a change of an existing right. So you complete the form. There's fees that are set by statute that have to accompany it, and they need to be supported by a map or maps. And these need to be drafted by a licensed water rights surveyor. Now you can reference existing maps if they are accurately depicting everything that you need to for your water right application. So that can, if it's possible to do that and you can reference it, that's a great way to save the cost of having a map drawn. But you can't always do that, especially if it's going to be a new point of diversion somewhere or a brand new location that you're placing to use. Then you'll have to go through a water rights surveyor and have a map drafted for you. The application process. So if you squint really carefully, you can see in the upper left-hand corner. Oh, wait, sorry, I'm just kidding. It's a little bit simpler than that, so it feels like that previous slide. So here's where I'll get into a little bit on the question earlier about certificated versus non-certificated. So with the application process, as I described, you're going to file an application. It comes in. There's some clerical type work that happens with it. We create the file. The initial information is input into our database, and then it gets routed to something we call map table. And that's where we do this step here that's review application for completeness. So in this step, it's basically is everything filled out? If it's a change of an existing right, it's the information on there matching our records in terms of the existing right. Is the application's information matching the information on the map? Or the name's the same? Is the purpose described in the maps title section match up with the information that's in the application? You know, is the appropriator's name spelled the same? Was the stamp signed by the licensed water rights surveyor? They sign their stamp like they're supposed to. There's all the information on there. Is the scale right? All these kind of things. So it's just kind of this technical review. Is it complete enough for us to accept and then move forward with the process? If it's not, we return it for correction. And then there's an opportunity then to submit back to this office an amended application or map or whatever the issue was. And we have 30 days to either send it back for correction or to send it on to publication. If we send it back for correction, there's a 60-day window from that date that we send it in which to receive it. There is allowed to have a one-time 60-day extension if for some reason you can't make those corrections in that time period. If that doesn't happen and we don't get anything back or it's unsatisfactory, then it would be subject to cancellation at that point and you'd have to start over. But if everything does come back in and it looks good, or if it was already good to start with, then we would send it on to what we call publication. So we draft up a description of what the application is. Who made it, what kind of quantity, where's the point of diversion located, both in the technical survey system description, but also with a more generalized physical description, we call it. So parenthetically, it will say, 3 miles northwest of Carson City, rather than, where's the point at which the southeast corner of the section 5 of township, and so on and so forth. Where's that? Oh, well, it's in Carson City. Well, I'm in Elko, so maybe I don't really care. But that's the reason for that, at least give people an idea. So it goes to the paper. It has to be of record for that county in which it's located. So as I've been using Carson City as an example, would have to go to Nevada appeal. It goes for 4 consecutive weeks, once a week for 4 consecutive weeks. And then 30 days from that last date of publication is a protest period. Now it's possible anytime from time an application is received and we've assigned it its serial number until the end of that protest period, it could get protested. You don't have to wait until it actually goes to publication for that. So within this time frame, someone feels like they have some issue with it, can file a protest against the issuing of the right, or they could say, well, here's the reasons why we think you can issue it, but we think we should have these conditions on it. So if you're gonna move a new irrigation well right next to your neighbor's little domestic well, and they think that's gonna draw it down so that it dries up their well, they might file a protest, say, hey, this is gonna impinge on my rights under the domestic well lines. I shouldn't say right, I should say proprietary interest in the domestic well lines. Now, after that protest period passes, the application becomes what we call ready for action. Now, to be ready for action, protested if it got protested. There's kind of that parenthetical, it's ready for action, except there's a protest on it. Now, there's several paths it can take from there. If it's worth doing, we might perform a field investigation, try to get a better understanding. It could be one where either we're just going out to look, or it could be maybe a formal one. If it is protested, let's get the protestants and the applicants out there and let's take a look and talk about what's going on, and maybe we can get some kind of resolution. It's possible if it's very contentious and we don't have enough information, that we could conduct a hearing where we bring in the applicant and any protestants and okay, put on a case why the application is acceptable for us to approve versus why it isn't. Bit of an oversimplification, but that's the concept. What would come out of those would be a ruling. So if we were either to overrule protests or if we were to deny your application, we would condense the city engineer's decision down to a written ruling that would lay out the facts, the conclusions of law, and then the final ruling that says either we're overruling the protest and approving the application subject to certain conditions, or we're going to deny the ruling for these specific reasons. So we can go to this denial path or approval path. So if it gets denied, there is an option under our statutes that allows for any decision of the city engineer to be appealed to a district court of the jurisdiction in which the water right is potentially would have been located in. Under NRS 533-450, that allows any party aggrieved to make that appeal. It's a petition for judicial review. Similarly, even if we were to approve it, it might be that, say, the protestants think we shouldn't have done that and they find some kind of fault with it. They might also appeal that decision. So that's a possibility as well. Assuming all those hurdles are overcome, and we're actually going to issue, we believe at this point that it looks good to issue. There will have been a review by the water rights specialist. They will put their tentative permit terms together with the supporting documents of why they are recommending the approval and what limits maybe should be placed on the right. And if it passes the review committee, which is just kind of an ad hoc committee with various managers and supervisors. I tend to be on them most of the time, just as part of my role as the chief of the water rights section. But other section chiefs also join me in there. Other supervisors might as well, and or possibly deputy administrators and maybe even the state engineer if it's a particular policy concerns regarding it. So if it looks good at that point, we'll send it for the permit fees. Does not mean it's going to get issued because the buck still stops with the state engineer. But once we receive the fees, kind of do a last minute check on, okay, are these all the right terms we wanted? It's the right fees for the right type of use. It gets drafted up, presented to the state engineer, and he can still say no, or I have other questions, or or let's get some more information. So again, until the state engineer actually signs it, it's not a done deal. So it's a big step to get that fee letter, but it doesn't necessarily mean it's happening. So most of the time it does. Now, if we issue the permit, we now have this this temporary allowance in order to utilize the water. And this is where we're getting into that question about certificated versus non-certificated. At this point, there is no certificate associated with this water right. And what you're trying to do is establish this right to prove up on it. And you do that through first a proof of completion. And what's that? Well, it's a form that you would file that describes the diversion works that you've constructed. If it's an underground right, that would be a well. And so you describe your well. Here's the well log. Here's the meter description, serial number. You know, it was at 0 when installed. You know, helpful pictures with it are always good. Or if it's from a stream source, oh, it's, you know, I have a little check dam that, you know, I throw a tarp out there to divert when it's my turn on a rotation schedule or something like that. You know, whatever the works are, that's the description there. So that's the first step, is actually completing the works to divert the water. Then once you're able to divert the water, you're going to be putting it to beneficial use. So if it's an irrigation right, you're putting the water out onto your field to grow your crop. If it's a stock water right, you're diverting it to your troughs for your animals to drink from. And at some point, you're going to have to file that proof of beneficial use. If you don't use the full amount of your permit, you're going to be limited to the amount that you actually have used. So if you only used 80 acre feet of that 100 acre foot permit, and that's what you're going to prove up on, that's what this certificate is issued for, and that's going to be the limit of the right. So sometimes your due dates that are established under the permit come up, you're not quite ready. So you could file an extension of time application for the filing of either proof of completion, or if that's already been filed just for the beneficial use, or sometimes both, if you kind of caught up with both dates. And in there, you have to still demonstrate that you are proceeding with good faith and reasonable diligence. And reasonable diligence is a steady application of effort. So if you can come in with this form saying, oh, I put in, you know, 30 of my 40 acres last year, I plan on putting the other 10 in next year, you know, that's a good demonstration of, oh yeah, you're making progress. You know, so you have this incremental, you're moving forward, you're demonstrating that. So that's why we have this arrow that comes back up to that cancellation. If you fail to file, or failed on one of the proofs, or if you fail to file extension of time, or if it's determined that you're not proceeding in good faith and reasonable diligence, the water right could get canceled before it even reaches that certificate stage. And there are appeal process there. There's an internal one you have to do first, but then you can go to the district court if you don't like that decision. But let's say everything's working well. You put all your water to use, you file your proof of beneficial use form. We perform our field investigation that, ground truths or verifies the information in your proof of beneficial use form. It all looks good. We draft up a certificate. We now have fees for certificates. You'll get an error fee letter. It's by statute. And then we issue a certificate. So that's what the point we finally get a certificate. So again, the distinction is with the permit, before it's certificated, you're still trying to establish that right. And you're subject to cancellation if you don't prove up on it, if you don't show that steady application of effort to try to put that water to use and demonstrate that use. But once you have done that, and you get a certificate issued, you can continue, then you're kind of done with this application process. That's why it shows it as the terminal point. But as discussed early on in this presentation, if you fail to use the water year after year, after 4 years, you're going to get, or more, you're going to get a notice of non-use if we've identified that. And then you either have to cure that forfeiture by actually putting the water back to use, or you do have the option at that time again to file an extension of time to prevent the working of a forfeiture. So if we approve that, it'll give you additional time to try to cure the forfeiture by placing the water back to use. But if it's not cured and there's no extension of time approval to extend the working of the forfeiture, the right would then be subject to forfeiture and it would go away. All right. So again, those kind of in terms of appropriative rights, that's the 2 paths to getting a water right. Is there any questions now before we move to the next section?
Does anybody have a question they'd like to ask, or shall I just go to the chat questions? I think I'll just go to the chat. So the first question is, so let's say I drill a well and build a house and I use my 2 acre-feet yearly of water, both for household and to water my greenhouse, which I use to grow veggies for my family. If I decide to expand my operation and start selling those products, would I have to apply for a water right?
Yes, at that time you would. Because if it was just a garden for your family and your household, that's covered under that domestic use definition. But as soon as you change it to a commercial operation, then yes, you need either an irrigation right if you were growing crops, selling it, or if a lot of times with like a greenhouse operation, you might just call it a commercial manner of use because there might be other uses with that. You're washing things, and and if you have like a little storefront or something that comes into play where you have a restroom or something, you have these other uses. So some sort of water right would be required once you move beyond just, hey, this is for our family's use.
Okay. Second question is, in regards to supporting maps, what does preferred use, irrigation denied mean?
I will be getting into that very soon. So maybe I'll hold off on answering that and address it when I get to that. It's in the next section.
Okay, and then the third question is, what is the cost of applying? And if I get denied, can you apply and pay again?
Depends on there's a whole schedule of fees in the statute for the different types of water rights, whether it's an application to appropriate or change. And there's for the application up front versus the versus the fees for issuing the permit, and then the later fee for the certificates. So again, depends on the right. The permit fees I'm most familiar with. It's just a thing we deal with all the time. So for the different kinds of manner of use, so for most manners of use, if it's a new appropriation, it's like $360 plus $3 per acre foot. If it's a change in of an existing right, it's $300 plus $3 per acre foot. But there's some, but if it's irrigation that's not changing its manner of use, you're just changing, say, the point of diversion or the place of use, then it gets capped at $750. For stock water usage, it's $240 plus $50 per cubic foot per second or fraction thereof. So most of them tend to be under 1 cubic foot per second. So the fees kind of usually just $290. You round up times 50, it's $290. And then there's some other rights that have a little bit different fees. And then the certificate, for issuing the certificate, it's $350. And for the, I forget the proof of beneficial, I can show you guys where it is in the statutes when I go through the web. But so you can get a sense that there's kind of, it's all in that range of that, usually hundreds of dollars. Usually I don't see really big fees, and except for like the mines when they do a real big change of their big water rights, and you start seeing thousands and tens of thousands, but usually you're in that hundreds to $1,000 range.
And then the last the last question in the chat is, when purchasing irrigation water, do you take the purchase right subject to the tolling on the prior owner's beneficial use?
Oh, okay. If I understand what's being asked, so yeah, let's say you acquire, say, an existing right. You'll want to look at what's going on with that right, because it could be, if it's subject to forfeiture and they've been filing extensions to prevent the working of forfeiture, you want to make sure that it's something doesn't happen to it in the meantime while you're trying to update title, and so you might even have to take over that. We do look at the history of a water right. If we see this water right that keeps getting changed and kind of resetting the due dates for filing proofs, but nothing ever comes in, we might look at that in terms of, is this really getting placed in beneficial use? Of course, if you're a new owner, one of the things you can say, well, I can't be responsible for what the previous person did, but here's what I'm doing. So it's possible you want to be careful about what right is acquired and kind of pay attention to that. And if you were just taking over and you weren't filing an application to change, say you bought the whole farm and you got the water rights with it, then all those due dates are still right where they're at. It's still, if you already have 5 extensions over the last 5 years, that's still the history of that right, and you'll still want to try to demonstrate that you are proceeding with good faith and reasonable diligence to keep that right alive while you put it to use. So kind of sort of a long answer to a much shorter question, but if I'm grasping what the question was, if not, please clarify or provide some rephrasing or something.
I think it's good. I have a question. I just wanted to know, how long is the average application process?
Average. What we try to do is, from the time the application comes in, is to have it processed within a year. It can be, if it's the smoothest going, it doesn't get protested, there were no problems that had it returned for correction, everything's good, the ownership's already up to date. If it's a change out, 6 months is probably a pretty good pace. There's certain rights that get expedited, like temporary changes, but I haven't really gotten into that with this presentation. But there's there's things that can start holding it. Like I said, if it gets protested, well, we have to go through the extra process of, okay, what are the protest issues? You have your opportunity to file an answer. That can really delay it. If you are in a basin and it's a new appropriation and there's a new appropriation application in front of yours, we'd have to, that was filed, had it in front of yours that we haven't permitted yet, we would have to do that one first. So that's another potential delay. So best case, smooth, 6 months. What we target is try to do under a year. That's been our traditional backlog number or time frame. And we kind of keep that for historical sake to see how much we have that might have slipped into beyond a year since the RFA date. So after it went past the protest period. And so that's where you're looking. And so one giant caveat I have to put in is that's assuming that we have staff doing it. Right now, we're down several people just between some people leaving and promotions and so forth. And so even though we hired a few people, they were internal promotions. We still have a few spots open. So we're already very busy, but then with positions to fill and people in new positions, just understand it might take us longer right now, just as we're trying to get back up to full staff. But those are still our same target windows.
Okay, we had a question come in on the chat that asked, water rights are for lifetime or are they limited for certain years?
Lifetime. Most rights, as long as they're maintained, are pretty much indefinite. There are certain types of rights that might have a limited time span on them. There's a provision in the statute that allows for water rights that are for temporary use or temporary time frame. And a lot of the times those are for a very specific project. For example, a mine that's estimating will play out in about 10 years. We're in a basin that has more rights appropriated than the perennial yield, which is like the amount that you could draw per year without depleting the aquifer. But the pumpage is actually under that amount. So in terms of actual uses, there's some available. So yeah, in the short term, you could use that. So we might issue a permit then that says, okay, this permit is good, but it expires, this date 10 years from now. Otherwise, for most water rights, as long as they are maintained and beneficial use is performed on it, so it doesn't become subject to forfeiture, it'd be indefinite how long that right lasts.
Okay. We got another question. What counts as proof of beneficial use if a well is unmetered?
Well, our rights would require typically that there be some kind of measuring device or a meter, especially for a groundwater right, you probably require a meter. The ones that we tend not to is say stock water rights that are remote, just owing to the fact that usually it's like a windmill or something that's just kind of drives it and easy for someone to go vandalize or steal the meter off of it, and we sort of recognize that. So in that case, it's just tell us the number of animals, that's the quantity of the right. for an irrigation right where we did not require a meter, and we just say, measuring device, one way establishing it is be the number of acres that are irrigated. And typically that would occur less like with an underground right with a well, and more of, say, it was a change of decreed surface water right. The decree already establishes, there's a certain number of acre feet per acre on this right. So just by virtue of, I moved it over to my parcel, I took these 20 acres I acquired, moved it to the new parcel that has, I put the 20 acres to beneficial use. That's how you establish it. Well, you say, hey, this is where I used it. We can look at aerials. We can go out and look at the field. Oh, yep, that's the acreage. And based on that, be able to issue a certificate.
Okay, and then maybe you could just do a little confirmation on this other question, not question, but comment. Is that ag water well is metered and residentials are the only ones that are unmetered?
No.
Okay,
Anything with a water right that's like a modern one we'd issue, you pretty much should expect that we would require a meter for it. Now, if you mean by a domestic well, we haven't required meters on those unless they're a very specific case, as I described earlier. Either because it's something that there's a complaint on, or we're concerned about you're overusing it, or if you have the accessory dwelling, where we have to make sure, even though you have the second house, even though it might not be a full-blown house, that you're not exceeding that 2 acre feet. That's one of the requirements to be a meter. So there's cases where, yes, you would require a meter on, say, even a domestic well that doesn't require a water right. But almost certainly, at least if it's a newer right that we issue, there would be a meter requirement for a well.
all right. I think we're ready to move forward.
Okay.
Thank you.
Yes, thank you. Good question. So, speaking of wells, so kind of go into wells and well drilling. This is more of my other chief's bailiwick, and his office is next to mine. But it does come into play with water rights as well. So, as I alluded to earlier, if you're going to have a well drill, it needs to be drilled by a licensed well driller. And what would happen is they would file a notice of intent card with us, and then we would authorize that, yeah, you can proceed. And the reason for that is to make sure that it's falling under one of these criteria that there can be a well. There has to be some purpose for the well, otherwise it needs to be plugged and abandoned per statute and regs. So if it's a domestic well, okay, if it's in a location where you're allowed to drill a domestic well, okay. If it falls under one of the waivers that are allowed, like an example I have on the screen here, highway construction or a mineral exploration waiver, or it has to have a water right. That's going to be there. Now, I have to take a little bit of a side on that, especially the last one. So this gets back to a question that was asked earlier about designated basins and irrigation denied and things like that. Don't try to squint to see the map there. That's our latest and greatest version, but I can show you where it is on our website where you can actually zoom in and make sense of it. So there's two paths to a basin being designated. One is the appropriators within the basin petition the state engineer, and then he can do his investigations and make a determination whether it should be designated for additional administration. The other path is if the state engineer believes it should be designated, it needs this additional information or administration. The state engineer could hold a hearing and receive that input and testimony from the public, and then decide whether to issue an order to designate the basin. Now, to make sure before I move on, to make sure I kind of cover the question earlier, once a basin's designated, it creates an ability for rulemaking under the statute. I'm referencing on this slide the NRS 534030. That's specific to the basin becoming designated. Under 534.120, that allows within designated basins, the state engineer makes certain rules for the proper management of the basin. That's the additional administration. So when you see on this map with the different headings, again, I can take you to the good one eventually. You can zoom in. It just says designated. That means it's just designated, and I'll get to in a minute what the effect has on wells. But if it says designated preferred use, that means there's an order that's been issued that says there's a preferred use, which is allowed under the statute, of a certain manner of use. So it might be an area around, say, Battle Mountain or Tonopah, where it says, okay, in this area that's been described, it's a portion of the basin, there's a preferred use for municipal and industrial, because we want to make sure there's water available for that community within the basin. If you see preferred use irrigation denied, its order is written such that basically it's saying that all other uses besides irrigation are the preferred use, and then it kind of takes the next step of saying new applications for irrigation rights will be denied. Doesn't necessarily mean so within that basin, you probably have to acquire an existing irrigation right and move it to your place of use, or acquire the whole ranch or something if you wanted to be able to use an irrigation right in that basin. Usually that only occurs because it's over appropriated, or we are seeing that there's a decline in water levels, and irrigation tends to be the big water user relatively to other manners of use. And so that's the way to kind of stop additional uses without preventing, say, like little stockwater rights to still be appropriated. So hopefully that kind of clarifies that terminology, but it kind of comes down to what's specifically written in any orders that are for that basin. And I can show when I go through the website here what you can look up and how to see that. So after our little aside here, so the importance of designated basins in terms of drilling a well, there's two sections in the statutes about that. So in a designated basin, you have to have obtained your permit for a water right before a well driller can come in and drill a well for it. If the basin has not been designated, you don't have to wait until you actually have that water right to drill a well. But you still can't use the water until you have that water right. So you're kind of taking a gamble in the sense of, well, you paid all this money to drill a well. If the right doesn't get issued and you don't have a permit for it, you're gonna have to pay all the money again to have it plugged and abandoned. So unless you're feeling pretty confident, you might not want to go down that route, but that is a possibility. So to kind of summarize that, designated basin, need the water right first. Non-designated basin, excuse me, I didn't think that was a tongue twister. Non-designated basin, you can drill before you actually have that water right permit, but you're going to be that risk of it not actually getting issued, and then you might end up having to plug it. So relatively short section. Got extended a little bit talking about designated basins, but any questions on that? I didn't get into it too much. I thought the most important aspect is what's shown here. You licensed well driller for drilling wells.
So we have a few questions in the chat. Is
Alright.
there a list of preferred uses we can review? Is that on the website?
It's spelled out specifically in statute, so I can show you where that is.
Okay. And then the second question is, so is it even worth petitioning for water rights in an area that is preferred use irrigation denied?
To make a new appropriation application, if there's an order that says will not approve on those grounds, no, unless you think the conditions have changed since then. Because you'll probably want to be going through, your professionals, your get an agent like a water rights surveyor that knows their stuff. If they can actually demonstrate, well, that was true back when the order was issued, but today, there's been these forfeitures and there's, this condition happened and there's a revision of the perennial yield. So, we think there is water available and, consider our app. And that would be the way to get in front of the state engineer for consideration. But absent some strong evidence that maybe we need to change that order or absence, a strong argument of, oh, well, this is just trying to replace a right that got canceled and we didn't realize. And there's maybe a possibility, but, are they getting issued and really try to make that claim? You can always make the application. But absent some really strong and convincing reasoning for why we might go against that order, probably not worth the time. We'd be better off seeking out existing rights that were already irrigation manner of use and acquiring those.
Thank you. That was helpful. Those are all the questions right now.
Okay. All right, so last little section is on resources. So I wanted to kick off and just kind of say, here's where our offices are. This is getting recorded, and I provided a copy of the presentation, and, so you'd be able to track that down. Don't have to break your wrist trying to write all this down or anything. So our main office here is in Carson City. It's at the Bryan Building on the second floor. We also have our next largest branch is in the Las Vegas office. They're also available for people that want to walk in and get some assistance. And we also have our Elko office, which, like the Vegas office, it's not as big, but you could still say turn in extension of time forms and things like that. They can stamp it in. And then we also have a couple of field offices in Winnemucca and Eureka. Basically, there's one person in each of those that handle either water commissioner duties or help us with field investigations and so forth. So specific to the Carson City office here, again, to kind of reiterate what I said right in the beginning, this is very broad overview type of stuff. So if you have more specific questions, we're happy to be available and answer them, especially if you're like, well, I'm looking at this basin, what's going on here? Or I'm looking at this water rate, and I need to understand what it's about. Is it something reasonable for me to pursue? Or we can't provide that kind of advice. You're best off once you're kind of going down that road, maybe since you might have to hire a water rights surveyor anyway in order to get a map done. A lot of times they can act as agents and provide actual advice. We can provide information though, and we can provide scenarios and examples of things that have happened in the past of, well, you could do this application, nothing can stop you from doing it, but you know, the last 3 people that did this were denied, so take that with your considerations. Just as a off the cuff example. And if it's water right related, you know, well, if you call the main line, we can try to get you to the right person. So if it's water rate related, go to one of our basin specialists. If it's well related, to a well supervisor. If it's questions about the title and our process there, and you know, get this to one of our D techs who are very well versed in those kind of questions. And then we do, you know, for physical location, walk-ins are welcome. Used to be a little bit easier to get in here, but the director's office is just do a little bit more security with people coming into the building. That kind of came about during the course of the lockdown with COVID, and then we had just kind of skeleton crews here in the office. So we'll have to either check in with the receptionist that's downstairs or into the director's office there. No one's out front. Otherwise, call our office and say, "Oh, hey, I'm here. Here's why I'm here," and we'll get someone down to escort you up. Or if you've already been talking to one of our basis specialists, like, "Oh, I want to come down and talk to you about something," just kind of make a little appointment so we know you're coming and can just kind of set aside that time and be available for you. So then, so in continuing off the resource idea, I wanted to now kind of take you through a lot of stuff, and I've been alluding to a lot of things that rather than trying to post static examples within a PowerPoint, I just rather just take the time now to go through and show. Okay. So hopefully it transitioned okay, and you can see the website. If not, someone yell at me.
It looks good.
Okay, thank you. So I'm going to walk you through this. Eventually, we're going to have a new version of our website that's been in development for a while that hopefully will be a little more intuitive. But in the meantime, regardless, it's not going to be the same kind of information available. But in the meantime, I'll kind of show you where it actually is on here. Kind of starting with the homepage here. We have, you know, and feel free to go here and check out other stuff, but I wanted to point out some really valuable stuff. One is like this general publications. If you go through that, it shows, you know, this is a link that goes to the legislature site, or will, those links under it will. Those are all those statutes that I listed in the beginning of the presentation. So that's where you can find some of those things we were discussing. So for example, fees of the signature. That's not the fee schedule now. So most of them are here. There's a couple are in their own sections, like for environmental, they have their own little section that has them. Might take a little bit of interpretation, but that's where they're all listed. Here's the NRS, but you can see I just did a search within the page. Otherwise, back up at the top, there's the index. You can see it took us over to the LCB site, the legislative branch's site that shows all of these. We go back to I opened it in Newtown. All right, Newtown. Under 534, there was a question about preferred uses. So this is what I was talking about with the, to make rules and regulations and orders within a designated basin. And then it's here that describes which uses. Now there's manners of use beyond it, but these are the ones that are specifically called out for the preferred use categories. So first, domestic, municipal, quasi-municipal, industrial, irrigation, mining, and stock watering uses. So there are other uses that aren't on that list, such as wildlife, power, recreation. There's probably the catch-all other. But these are the ones that are explicitly stated in the statute that we could do a preferred use for. So coming back to that general publications page, there is a very valuable one right here. It's the summary of statutory procedures, filing claims of vested right. Again, that was the other type of water right that I was describing and said we wouldn't really cover in this presentation, or make an application for a water right, and then summary of fees. So a lot like this presentation I gave, it kind of has some description of water law in Nevada, what these different types of rights are, and how to go about making your applications. So that's why it's a really valuable resource. It covers a lot of the similar information that I described, just in a little bit different way. Gets into a little more detail about the criteria for approval or denial. Yeah. Including some things you probably won't be involved in, like artificial groundwater recharge and recovery projects. So that's usually like a municipality or something like Temwa that, we want to divert water into a infiltration well that'll put the water into the aquifer so it can be pumped out later. Yeah, so probably not within your normal purview what you'd be worried about. So here's a little bit easier to read version of those statutory fees, and we've also collected some of those from those other sections that I described and put it into this list. So here's the other ones that are in different places in the statute. So it might be a little easier to go to this document if you're wondering about fees. So I can really give you a sense of what kind of costs you're looking at just in terms of our fees. Now, obviously, there's going to be additional expenses if you have to hire a water rights surveyor to generate a map or to help to get the correct description of the point diversion location, place of use location, and so forth. That's outside our office. That's just your private agreements. There are other guidance documents in here. One that might be interesting is like the preparation of water rights maps. That's actually more for the water rights surveyors to have so that they're complying with what we want. Again, same with like the water well and related drilling. That's what the well drillers have to follow. So could be interesting, but probably a little less directly applicable. So going over to the next, we have a news tab here. If you really want to keep your finger on the pulse, you can go to it. We have a lot of older news stuff. The one that's probably going to be tying most directly back into this entire presentation is this forums room, particularly with the water rights and deed title tabs. Under water rights, we're slowly updating our forms and we're giving them numbers. So if you don't see this little form number out in front, it's just because we haven't updated that form yet. To try to, because as you can see, there's lots of forms. We're hoping that'll make it easier to be able to reference. We're talking to you on the phone. Oh, for this specific thing you're telling us, you'll want 1021F, not 1022F. Just because the descriptions are very similar and it might maybe help clarify. So not quite there yet, but we're still in the process. So the ones you'll be looking at for making an application, this one that has nothing else hyphenated after it is your new appropriation application. And the next one down is that change of an existing right. And as I was mentioning before, there are some other types that I didn't get into. So I'm not going to go into it much more now here either. And also in this tab, here's what we're talking about with proof of beneficial use. We have different forms depending on the manner of use, and then the proof of completion forms. So the here's how we constructed it. So whether a meter was required or not. Those are two different versions. Usually if it's no meter required, it's either because, like I said, it's that remote stock well somewhere, or it's like a surface water right where it's not a meter, but you still have to have some kind of measuring device, a weir or something like that. So this just has additional information on it for filling out, like what's the meter serial number, what was the reading on the date of install, what was the date of install, and questions along those lines. So for a new appropriation, our update form will look a little different. They'll be asking the same stuff when it comes out, but this is what it is right now. Everything I talked about pretty much in the presentation is what's being asked for here. So who's the applicant? We need to know your contact info in case of, we need to return it for correction or to advise you of a protest or anything like that. So that's important to get right. And if it changes, it's really important to update us with your new address so that we're getting your notices to you. Because if we're sending it somewhere where you're not at and you're not getting your notices, something could happen, like the water right gets canceled. So we're trying to advise you of something, we hear nothing back, it goes away. So that's like really important to make sure that you're keeping up to date. So again, all these features that I talked about earlier, what's the source, what's the quantities, what's that manner of use. And as I was saying earlier as well, for certain uses, we're asking for certain pieces of information. Location of the point of diversion, location of the place of use, what's that period of use that you plan on using it, that description of the work. So if it's a well, it's going to be a drilled well, or if it's going to be, it's a spring, we want to improve the spring, so we'll install a spring box with a pipe that leads to the place of use. Or estimate of the cost, estimated time it would take you to construct the works, and the estimated time it will take you to put that water to beneficial use. Now, these are important dates to think about because you want them to be reasonable, but you want them to be realistic as well, because that's going to guide our decision on those due dates for filing the proof of completion or the proof of beneficial use. There are some statutory limits. There's caps on that. For the case of, like municipal, there's a minimum of 5 years here. There's a maximum of 10 years out, and then this would continue out from that date. And then something that kind of gets skimped on tends to be this description of the project. If your description is just, oh, it's for irrigation, well, we know that from the question earlier where you said the manner of use was irrigation. But, oh, we plan on growing a crop. Here's the crops we're looking into growing. Here's the, if it's a commercial business, oh, we plan on building a greenhouse and and have a storefront and so forth. Commercial right, you might want to give us a fixture count that says, oh, there's going to be this number of restrooms, and this number of coffee makers, and this number of various other elements and fixtures within the business. So those are the things, and that's why we say delay of processing, because, well, if we don't know what the project is and we don't understand it up front, we're going to have to send a letter or an email or something, or contact you and say, well, give us this description, help us understand what your project is. So, and you're not limited to this space. If you need to say see attached to put an attachment on there, by all means do it. Basic remarks, those are anything that's helpful for, oh yeah, you're trying to reference different maps or something that's supported, or whatever comes up. So it's right on the form what the filing fee is, so you should be able to see that right up front. So an application to change, again, it's very similar. You'll want this to be correct. It needs to match the vesting under the base right. And the base right is the right that you're trying to change. And when you first file, it might not match because you're still trying to update the title in our office of the existing right. But whatever you're updating it to, you want it to be the same as this, so that we know that, yeah, you're creating this potential change. You got to be the same person that owns the right. There's some wiggle room in certain cases, but for the most part, if it's going to be John Doe, you're going to want to put this, that's how the deed that conveyed the water right to you was John Doe. You'll want to write John Doe in this applicate field. Just check boxes for the type of change that's occurring. Again, if it's going to be a period of use change, you check this manner of use. What is it changing? You need to know what the right is that's being changed. So that could be a permit number and certificate. It's been certificated. If it's under, say a claim of vested right or a decreed right. So say claim 76 of the Truckee River Final Decree. That's the description we need in here, so we know what the water right is. It's identified what's being changed. Otherwise, it's a lot of the same information. It's just we ask for, again, the source has to match. We're asking for the amounts that are being changed, and then the new manner of use, the old manner of use, the new point of diversion, the old point of diversion, and so forth. And the rest here is the same kind of information. How long, what are you proposing to build for diversion works? Estimate of cost, estimate of time frame to do it, estimated time frame for beneficial use, and that project description that I went on and on about. So just so you can kind of see what these look like real quick. Proof of completion of work. You're making an affirmation here. What's true. We one of the things we did when we were during the COVID lockdown a couple of years ago was kind of reevaluate how this affirmation or affidavit had to be, and so A lot of these forms used to require a notary. Many do not now. There's still some that do, especially if they're going to be recorded with the county, but there's one that does not. They're just making this certification here. And then for PBUs, there's the reason there's like different purposes because we ask the first page is the same on all of them. You know, who's filing the form, the permittee or the agent, and so forth. Description of the source, the meter, because this could have changed. You know, say your meter died, so it's not the same one you had on your proof of completion form. Well, here's the new meter. You're updating that information. The big one here is, what's the maximum you could divert? Say if you have a well, what's the maximum your pump could deliver? It's not necessarily what's on your permit. You should probably be able to exceed that in order to make sure you can meet it. You're not supposed to go over it, but you'll want to make sure that. Otherwise, it could limit you if it can't actually produce what's on the permit. And then how much are you actually proving up on? So I pulled up the irrigation one just as a quick example. I don't want to take too much time. I know we're kind of getting close to the 2 hours here, but so we're asking very specific questions. Again, can always attach additional sheets if needed because a lot of this is required by statute. You need to break it out by quarter, what number of irrigated acres and so forth. So again, for details and help with filling out any of these, you can certainly contact our office and we'll get a water resource specialist to help you out. So one of the other really valuable things that we have on here is our water rights database. There's a couple of ways to access it. One is just a permit search. So if you already know a number, you can plug that in. They'll take you to it or take it to options if there's some different ones. And it gives some summary information. It should be mostly accurate to what's in the file, but it's always good to double check the official record rather than rely on this. We do have some documents that are linked, like the actual permit, the certificate, and maps. So we have scans of those. The other one for searching, it's called a hydrographic abstract. So you can have criteria to create a list of water rights that are in a certain, say, basin, have a certain location or status, and so forth. So I can kind of help, what's in the basin, what's available, and it's another way to kind of search for information on anything that might be relevant if you're looking at acquiring water right or what else, or just to check on that stuff is accurately entered for one that you have, or check on updates. So another important one that kind of called Underground Active here, but it's actually several summaries that you could potentially have. So just to show what that looks like. Probably the most useful one is either this one, this general summary, or the commitments and availability, which is kind of an adaptation of the general summary but gives a number at the bottom of what might be available. So this gives descriptions. It has links to orders if they're standing unit orders. That's where we get back to that question about designated basins. That's where they would show up there. There's another route to that as well, which I'll show you in a moment. So yeah, you can see summary information. We're looking at Pueblo Valley. You have this perennial yield number, which is it's an estimate of what we believe based on this reference, this USGS recon report is available in the basin to be utilized every year without depleting the basin. So you can see in this case, this total is much higher than that perennial yield number. And like I said, there's a commitments and availability one. So with this one, you can see it's kind of has some of the similar information, but it dials it down just to more of the commitment information. Doesn't give the extra information about the what orders are in the basin or if it's designated and so forth. But it does give you a tally of the different uses, estimate of the domestic well use commitment, estimate or the groundwater reserve per this statute. And so basically water that can't be touched. And so it gives you this, and I'm going to call it an estimate because this is just pulling numbers from the database. It's not an in-depth analysis of what might be available, which is why we have this warning down here that it's a simplified estimate. So it might take a little bit more research into it, but at least you know from it that there could be something available. Okay, kind of walking it back in. So standards, order list, and search. There's different ways to get to these things as well, like through the mapping and data tab will get you back to these same kind of links. So if you had a particular basin you're interested in, click on Quinn River here. Oh, I know. There's Diamond Valley. See all these orders that affect it. So we could have these orders that, no. Oh, we can't. Okay. Sort of. These early designation orders, that's what created that rulemaking ability for the basin. Different orders that were ordering limitations on the rights that could be applied for. Probably multiple designations because it might have just been a portion of the basin, but then continued on to make more. It's the only one where we've issued a critical management area designation. I didn't get into that at all, but that's why I showed this one. It has a lot going on with it. Domestic well credits, that's a very specific rule. It's allowed for in the statute, calling for adjudication. So that's the kind of place you would go to see, in a particular basin, what's going on in there, and what's in effect, and so forth. Water law, again, multiple places, like I said, to get to similar kind of stuff, like the statutory authority. That's just that big list again. Programs, information about our different, relative to our different sections in the, so we already pretty much covered what I was talking about. Again, I went to mapping and data, kind of gets us back to the same kind of searches and so forth. One thing I do want to show is mapping application links. There's several of them. I want to bring up this one real quick. It's probably the one you're most likely to use. So it's just the water rights mapping. And so it's a way to kind of get in here and see what's going on and kind of a visual effect. So different types of points of use, points of diversion, excuse me, places of use. Governorsville. Yeah. See, what's not reflected is like the municipal right, because it would just cover everything and you wouldn't be able to see anything else. So go a little further south, though, you can see like we have pivots and they have water rights on these. So out in Carson Valley. Well drilling dam, well drilling and dam data. So we have the well log search. So that's, if you know a well log or you're trying to find one, you might be able to search on there. So the well log is what the well driller supplies to us after they've completed a well or completed plugging a well or did some kind of reconditioning. We also have our FAQ page, and let's see. Said I would bring up. That. So here's the actual map that I just kind of did a little screen cap of in the presentation that shows that different designations. So there's kind of the color coding. Our old one used different kind of hatching, which was helpful if we got like, if we made like a black and white printout, but our current one just uses color. So within here you can see that's where these kind of phrases were coming up. To be honest, I'm not sure what the distinction between these are, because once you say irrigation denied, you're basically saying everything else is a preferred use, but maybe we don't call it out that way in the order. So that's one way to kind of look out for it. So just because it's designated doesn't mean it's some people interpret that to mean it's a closed basin or there's nothing new. You need to look at the order and see. It might not have any kind of limitations on it. It just means that there's that additional administrative tools that the state engineer has for that basin.
So Malcolm, we have a participant that has a question that he would like to ask you himself. Cody?
Okay. By all means.
Yeah, thanks, Malcolm. I appreciate all the information that you're showing us. I have quite a bit more research to do, obviously, in regards to what you're showing us, but I'm looking at the opportunity to potentially purchase some land, but hopefully get water rights to, to farm on. Would it be preferable to work with a water rights surveyor on either finding water rights that I can transfer that are in my location? Or, I mean, I see there's a lot of information here you showed where there's like the appropriation or water rights that are up for grabs for transfer on the website. Who would have more information? Who would I want to get with to dig deeper into this?
Well, if you're willing to kind of dig into it yourself, you can do that, and then you can certainly call our office or shoot us an email to get some additional information. Like I said, though, we can't really advise you on any course of action, but we can provide information and try to convey understanding of based on the circumstances you described. It can be very helpful if you're feeling overwhelmed to have that water right surveyor or other water right professional. There's also attorneys and people that aren't water right surveyors, but they do some of that agent work as well. And if they need a map, they'll go to another surveyor, kind of subcontract in a way. So you can go down, the route of looking on the yellow pages or whatever the modern equivalent is these days. Or yeah, you could go to a licensed water right surveyor, because it's entirely possible. And more than likely that you'll need to go to one anyway for the purposes of drafting up a map in support of your application. And that was one other item I was going to point out here was we do have a list of, and also we have a list of well drillers under the well drilling dam data tab of water rights surveyors. So you can kind of look, you know their name, you can double check what they are. Otherwise, you can search by city, so you can look for something that's you know, kind of nearby. So,
All right. Looking at,
right
in regards to the supporting maps that you've shown us, I live in Spring Creek, which is just outside Elko, and it's
Mhm.
some of the land that I'm interested in is just kind of outside that preferred use irrigation denied area.
Mhm.
I'm not quite, you know, it's kind of on the verge on where that line's drawn. So I think I'll try and dig a little bit deeper and get with some of these people that you have shown here on the mapping and data list.
Okay. Yeah. I mean, you know, it can be very valuable to have that professional, especially someone that's been doing it a while, know what they're doing, have that experience.
Yeah, I mean, the last thing I want to do is
I can't recommend anyone or say that, oh yeah, you definitely, but you do have that, clearly have that step of you need to be able to give the proper description of the right location and so forth. So you're already going to have to retain them in one capacity. So
yeah, for sure. And the last thing I want to do is, you know, buy land and not be able to get water rights, you know, based on whatever the orders are. So just try to reduce that risk. But thank you very much for everything you've shown tonight.
Malcolm, we have a question in the chat. If you could just give a definition or explain the differences between, what is the difference between water shares and water rights?
water share isn't a normal thing. Sometimes you might have a share like in a ditch company, which is just your partial ownership. So that's they're delivering the water, but the water right is what you have. That if I have a water right on a system, then I get that delivery as long as I'm in priority for that delivery. But your shares on the ditch might relate to how much they'll convey, and it goes to in the ditch company for all the maintenance and so forth. There is the unique case of, I brought up Diamond Valley, where in conformance with the critical management area order, they were to put together a plan for the groundwater management that would lead to removing that designation as a critical management area. And the plan that they conceived of and that we had approved and is currently stayed because of litigation issues, they created this idea of a share system where it kind of put all the water rights into one pool with sort of a single priority. And then they had this share system that you got a certain number of shares based on your priority date and the quantity of water you had. And it was a way for them to kind of, under their plan, manage the water. So it is not a normal thing, and strictly speaking, because the plan's been stayed by the court and it's not in effect, it's not a thing at all as of right now, unless they're able to move forward with that plan at some point.
Okay, thank you.
Mhm.
We have another question. I'm on a 5-acre domestic well, and my neighbors are growing grapevines on their 2.5 acre, or maybe it's 2 5-acre lots. How do I protect my rights to make sure they don't mess with my rights and force me to redrill my well?
So there is, if you believe that they're actually impairing your rights somehow, you can request us to investigate that. If they have water rights, or if they're just using domestic use, but maybe they're exceeding that use, or you know, and there are protections under the statutes for your interest in domestic wells. So if they really think they're impacting you somehow, then you can ask us to investigate. If it's a new water right they're trying to move, or get a new appropriation for additional water and you think it might impact, you can make your protest on that. So you'd have to be either watching our website and checking in on what's newly filed, or watch the local paper for in the legal ads for publication notices.
As of right now, there's no more questions in the chat. Does anybody else have any questions that they would like to ask? Or is there anything else you would like to share with us, Malcolm?
The last thing I was going to show on the website here is just the contact us page. So again, it has that same information as I had on the slide. So, you know, office hours, our phone number. So it's the main line. One of our receptionists can kind of get you to the right person if you describe what you're trying to ask about. We do have some of our direct lines if you already know someone that you've been talking with, or they're the person you're going to interact with. I think anyone that's in Vegas has the same number. It's just our Vegas main line. Some of like the city engineer and so forth, you're going to get the administrative assistant, not them directly. Otherwise, say like my number here, that's my direct line. So I might end up, depending on what it is, you might still end up with me passing it on to one of the water rights or water resource specialists to get back to you on. But that's why I said the main line might be a little bit better. But there's contact, and we also have our link for the email, so we'll get you the right email for sending something to them. And I think that's pretty much everything I was looking to cover. Hopefully, it was a lot to learn. And again, we're available if there's other questions. And if anyone's come up with something else in the meantime, feel free to mention it now.
I will say that calling the direct line works. That's how I got Malcolm to come and do this presentation, as I just called the receptionist and asked for help to get to the right person, and they got me to the right person. So it's a very friendly office, and I just want to thank you again so much for taking the time to come and share this information with us, because it is a big topic and can be very, very confusing.
Well, I appreciate the opportunity to provide this information and get some guidance about our office, where what we can provide, hopefully.
So if there isn't anything else, I think we can call it a night. And Stacy or Lindsay, is there anything else that we needed to make any announcements about?
Nope, I'm just going to stop the recording.